Welcome to Conversations Here and Now. It's Wednesday, July the 9th, and I'll be talking about Canada's bail system today. Everybody seems to be talking about it, and everybody has an opinion on it. But on the whole, a lot of people are somewhat upset about it. So let's start right from the beginning. What happens when a person gets charged? So in Canada, when a person is charged by police, they may be released by an appearance notice, a summons, undertaking, or they may be held for bail hearing. Now, if the police believe the accused is a flight risk or poses a danger to the public, they may detain the person for a bail hearing where a judge will decide whether the person is released or not. So an appearance notice, let's say, some of the smaller offenses like theft under, simple assault, mischief maybe under 5,000, that kind of thing. If the police officer is sure that you will show up in court and you're not going to cause any more problems, then they may issue what's called an appearance notice. It's a written notice issued by a police officer, signed by a police officer, directing the accused to appear in court on a specific date and time. Again, it's for less serious offenses. Summons. What's a summons? Summons is similar to an appearance notice, but summons is a court order. It's issued by the court branch. They're directing the accused to appear in court. It is issued by the court, not the police. Can be used for both summary and indictable offenses, but usually it's used for less serious offenses, where the police are sure that you will show up in court. An undertaking usually is issued at the police station. If you're arrested for an offense, again, if it's a less serious offense, the police may take you back to the police station and have you wait while they type up the undertaking. Excuse me. And then basically they'll give you the undertaking and they'll have your court date and the conditions that they want you to follow, and you sign for it. So now we come to the more serious offenses. Okay, such as we're talking about murder, violent offenses involving firearms, terrorism, attempted murder, very serious assaults, assault caused bodily harm, that kind of thing. So very serious offenses. So if the police believe that the accused is a flight risk, after you release him, he may take off. They have just about everybody has passports these days, and then he may leave the country. So if they believe that or he may just disappear somewhere, even in the city. If you're a flight risk or a danger to the public, continuing danger to the public, they may detain the accused and bring them before a judge for a bail hearing. That usually has to be within 24 hours. So it's at the bail hearing that the judge will decide whether to release the accused with or without conditions, including financial conditions. This is where it can happen. Or they can decide, the judge can decide if they should be kept in custody. I don't think most people are aware how bail actually works. So bail laws prioritize the release of an individual charged with criminal offenses before their trial, unless there's a compelling reason to deny it. So the legal framework for this is in our Canadian Charter of Rights and Freedoms. It ensures the right to reasonable bail. Reasonable bail, meaning individuals are not denied bail without just cause. There has to be a reason why you're denied bail. Bail can be granted with or without conditions, and the conditions must be reasonable and they must be appropriate. So I'm going to give you a little more of a detailed breakdown now. So number one, right to reasonable bail. The Canadian Charter of Rights and Freedom guarantees the right to be released on reasonable bail. The right is not absolute. Bail can be denied if there is a just cause, and the just cause is determined by court, considering factors like seriousness of the offense, the accused's previous criminal record, and the risk to public safety. So at the bail hearing, again, the purpose of the bail is to ensure the accused attends court, protects the public, and maintains confidence in the justice system. Bail hearing usually happens within 24 hours of the arrest. Now, at the bail hearing, the judge or justice of the peace, and it's usually a justice of the peace, considers arguments from both prosecution and the defense. The prosecution presents evidence and arguments to support detaining the accused, to keep them locked up. Okay, that's what the prosecution is going to give their side of it and say, hey, this guy's very dangerous, he may take off, or he'll commit crimes again, and they'll present that to the justice of the peace, and to keep the accused in detention, locked up. The defense, of course, presents evidence and arguments to support the accused's release on bail. Okay, so the defense will give their side of it and say, hey, no, really, this person's not that dangerous. He's not going to take off, and things like that. He has roots in the community. He has employment. He has to go to work. He has a family and that kind of thing. So they'll present all of those arguments and say that this person should be released in bail. The justice of the peace, and sometimes it's a judge as well, but mostly it's the justice of the peace, almost all the time, then decide whether to grant or deny bail. Okay? Now, if bail is granted, bail conditions are imposed to ensure the accused attends court and does not commit further offenses and protects the public. Okay? These conditions can include reporting to a bail supervisor, residing at a specific address, having no contact with certain individuals like victims or witnesses or other people that have a criminal record. These are bail conditions that are put on if the person is granted bail. They have to surrender any weapons they might have registered to them. They have to surrender those. They may have a curfew. From some people have 24, they have to be reasonable curfews, because if the person has to attend work, medical, and that kind of thing, all that has to be taken into account. But definitely a curfew from like 9 o'clock at night to 7 o'clock in the morning, that kind of thing. You can't be going out at night committing crimes again. So they have a curfew. And geographic restrictions, such as you must reside within the town of, not the town, it's not only the city of Mississauga or region of Peel, that kind of thing. Okay, so and if the justice of the peace has decided that you will get bail, then they can, depending on your criminal record, depending on the crime, the seriousness of the crime, again, your what the defense presents, the judge may grant bail with conditions that are very light, okay, or they may grant bail with very onerous conditions on them to try and make sure that this person doesn't commit crimes again, right? So those are the bail conditions, and there's something called reverse onus. So in some cases, the reverse onus principle applies. This means that the burden of proof shifts to the accused to demonstrate why they should be released on bail. This is often the case for serious offenses like murder or drug trafficking or serious weapons-related gun, that kind of thing, offenses. Okay, maybe the accused has a pretty serious criminal record previously, have breached their previous bail conditions. So, the judge may say, well, you're in past, you didn't follow your bail conditions, so why should I release you? So you, as the accused, have to show why you should be released. Maybe you will say things like, I'm really sorry I did, this happened, and you have roots in the community, you've got a family, you've got a job. If you're not released, you'll lose your job, employment. You have medical needs that maybe need, appointments, regular appointments with the doctor, that kind of thing. So it's reverse onus, and you have to definitely prove that you're not going to, recommit crimes again if you are released on bail. Okay, so that's called reverse onus. Now, bail reviews. If bail is denied or the conditions are considered too restrictive, the accused can request a bail review. Okay, this involves presenting the case to a higher court to reconsider the initial decision. So, but in that meantime, that person is going to stay locked up. They're not going to be released. So if they have, if they have a lawyer, then that lawyer has to do an application to a higher court, to a higher level, and say, listen, our client should be released. And the types of bail. So I'm going to look at. And again, if the bail is completely denied, the accused stays in custody until their trial takes place. All right. So it could be 2, 3, 4, 5, 6 months down the road. That's not the point. The point is the justice of the peace or the judge didn't feel comfortable granting them bail and having them walk around out in the community, so they keep them locked up. So if you're being released on a bail, the court decides to release you, you'll be given one of these following: an undertaking without conditions, undertaking with conditions. You'll be released on your own recognizance, bail program recognizance, surety recognizance, and residential surety recognizance. So an undertaking without conditions means you promise to come to court when required. This type of release is like a promise to appear that the police would have issued, except it is issued in a bail court. So you're given a court date. This was just a bail hearing. You're given a court date down the road. You have no conditions on you. You sign for it, and you promise to appear at that court date. Undertaking with conditions. An undertaking with conditions means you promise to come to court and to follow other conditions as well. This type of release restricts your freedom more than an undertaking without conditions. You may keep the peace and be of good behavior. Do not contact the victim. Do not be in company of other people with criminal records. Do not attend certain addresses. Do not leave the region of Peel, that kind of thing, okay? Or wherever it may be. So you sign for it, you got your court date, and you promise to show up in court. You can be also released on your own recognizance. That means when you're released on your own recognizance, you must agree to follow certain conditions set up by the court, okay? As I've already talked about the conditions. You also pledge or promise a specific amount of money to the court as a security for your release, and you sign your own bail. So by signing your own bail, you agree to promise to pay a specific amount of money to the court if you do not follow your bail conditions. You don't have to have like $2,500 or $5,000 in your pocket. But basically what you're saying is, if I'll follow these conditions, and I'll show up for my court trial, and if I don't do any of these things, then I'm liable for the $2,500 or $5,000 or what may be. So that's called being released on your own recognizance. Now, as I said, bail program recognizance. A bail program recognizance is when a caseworker in the bail program checks that you are following your bail conditions. Okay, most jurisdictions, especially in the GTA, have that. They can have the police check. They can check themselves. They can call you, see if you're home at certain times, things like that. And you're following the conditions that are set. So that's a bail program recognizance. The next one is surety recognizance. A surety recognizance means someone must come to court: mom, dad, brother, sister, maybe friend. A surety recognizance means someone must come to court and agree to supervise you. Okay, so the court thinks, yeah, you may not show up, or you've broken bail conditions before, so we need somebody else to say, yeah, I will make sure that this person is going to follow all their bail conditions and will show up in court. So your surety must also promise a specific amount of money as a security to the court. If you do not follow the conditions of your bail, if you do not follow the conditions of your bail that's been set, and the surety signed for those conditions, and you're breaking those conditions, the surety has to report you to the police and say, listen, I signed for this person, I signed for their bail, but now they're not following their conditions, such as they have a curfew and they're out when they have a curfew. When they should be home, they're not home. So the surety can call up the police and say, hey, listen, this guy's not following their conditions. I don't want to lose my money. I'm just letting you know this guy's not following their conditions, okay? So, however, if they don't report you, then the surety may have to pay the money that they promised to the court. Again, in court, nobody has to show up with $5,000 in cash. It's just a promise made, and if you don't follow your bail conditions, the surety doesn't report, then they can be made to come to court. Not only will you get arrested, not only will you get charged for breach of probation, breaching your conditions, the surety may, not saying will, may have to pay that money they promised. So, now, another one is residential surety bail. A residential surety bail means someone must come to court and agree to supervise you, and you must live with that person. So surety recognizance since it doesn't necessarily mean you have to live with that person, but they just have to supervise you. However, a residential surety bail means someone must come to court and agree to supervise you and must live with that person. Your surety must promise to pay the court a specific amount of money as a security to the court. If you do not follow the conditions of your bail, and your surety does not report you, your surety may have to pay the money they promised to the court. So in none of these, you always hear the surety had to put up 50,000 or 5,000, 10,000. These are signatures that they do and promise to pay if you don't follow your bail conditions, or if you go out and commit crimes again, okay? The bail conditions that can be on your bail: given curfew conditions, you must stay home during those specific hours, usually overnight. If you're given a house arrest conditions, and that can be some very violent offenses, you must stay home at all times. In certain situations, you might be allowed to go out with your surety, such as job, medical, etc. Your surety must be always at your side while you are out. So, for example, medical. I don't know if that would work out with a job. So if you're working, you may end up losing your job. You may also need to wear an ankle monitor that will track your location. The monitor will tell the police if you go somewhere you're not supposed to go. And furthermore, most police services, at least in the GTA, bigger police services, they have a bureau that's in charge of checking if you're following your bail conditions. Okay, of course, the police can check this computer and see who was released today and what their conditions are, or who was released a week ago, what their conditions are. And their job is to go knock on the door and make sure they're following the curfew. They're not doing anything that they shouldn't be doing. So this is how bail works. So again, if you are not provided bail, then basically what happens is you're held in custody, in jail, until your trial date comes up. Okay, sometimes depending on the seriousness of the offense, if it's like a murder trial, that can take 2 or 3 weeks of court time. That can take a little while. So that person may be in custody for maybe, who knows, 6 months to a year before that much block of time becomes available for their trial. So Section 11E of the Canadian Charter of Rights and Freedoms guarantees, okay, this is our Charter of Rights and Canadian Charter of Rights and Freedoms, Canadian Charter of Rights and Freedoms. It guarantees that anyone charged with an offense, Section 11E, anyone charged with an offense has the right not to be denied reasonable bail without just cause. Okay, this means that while a court can deny bail, it must have a valid reason, and the bail conditions, if granted, must be reasonable. So, again, what is reasonable bail? This refers to the terms of the bail, including any monetary requirements, bail amount, and any conditions or restrictions placed on the accused liberty while on release. The bail conditions cannot be unreasonable, okay? This is the second one, just cause. The onus is on the Crown, the prosecution, to demonstrate why bail should be denied. This requires the Crown to show that there is a valid and sufficient reason to believe that the accused poses a flight risk or a danger to the public or would interfere with the administration of justice. So, the Crown will look at your previous, the offense itself, how serious it was, murder again, violent offenses with weapons, terrorism, attempt murder, very, very serious assault. So, and what your past criminal record is like, and if you have a previous criminal record, for those offenses, if you were released on bail, did you follow your bail conditions? Did you breach your bail conditions? And they find you and rearrest you. So all those things are presented, okay? So broad interpretation. The term bail in Section 11E is not limited to monetary amounts, but encompasses all terms of release, okay? Including undertakings to appear, recognizances with sureties, and other conditions. So it completely covers everything, not just the money part of it that I had mentioned before. Essentially, Section 11E aims to prevent arbitrary detention before trial and ensures that individuals are not unnecessarily held in custody when a release or reasonable term is possible. If it's your first offense, if you've never been in trouble before, um, you know, you promise to show up at your trial, then obviously the justice of the peace is going to take that into account and provide you bail. So the arguments for a quick release. Okay, so if you've committed a serious crime, what are your arguments for a quick release? Okay, presumption of innocence. Individuals are presumed innocent until proven guilty, and prolonged detention before trial can negatively impact their lives and livelihoods. That's the basis of all our Western courts. You are presumed innocent until proven guilty. Okay, and again, if you've never been in trouble before, you're a straightforward guy, something has happened, so this prolonged detention you have a full-time job, you have a full-time family, and you've made a mistake, so this can negatively impact your life and livelihoods, so you may be released quickly. Right to liberty. The second one is the right to liberty. The Canadian Charter of Rights and Freedoms guarantees the rights to liberty, and denying bail requires just cause, as I've already covered that. The Crown has to present a good reason for you to stay locked up, okay? Because the Canadian Charter of Rights and Freedom guarantees our right to liberty, okay? And of course, reduced jail population. Quick releases can help reduce overcrowding in detention facilities and potentially save on costs associated with holding individuals before trial. And this is really important because our jails are already overcrowded, severely overcrowded. You've got like 8, 9, 10 people in a cell that are designed for 2 people. So, justices take that into account. Judges take that into account. And if you can be released with conditions, then they will release you. Access to legal counsel. A quick release allows individuals to better prepare their defense with the assistance of a legal counsel. Okay, so those are the reasons for releasing people. You're presumed innocent, you have a right to liberty, reduced jail population, and access to legal counsel. Okay, now there's arguments for caution for not releasing people. Public safety. First one, the most important one. The primary concern is to ensure the safety of the public and prevent individuals from reoffending or interfering with the administration of justice. So, if the judge sees in your previous criminal record that you breached your bail conditions before, some offense you committed in the past, you breached your bail conditions 4, 5, 6 times, obviously, chances are you're going to do it again, so they will not release you. Flight risk. There's a need to ensure individuals will appear for their court dates and not flee. Another is the severity of the offense. Okay, so the seriousness of the charges is a key factor in determining whether to grant bail and what conditions to impose. Okay, if you're for murder, terrorism, attempt, chances are you'll stay locked up. Your history of non-compliance. As I said before, individuals with a history of failing to appear in court or violating their bail conditions may be more likely to be detained until their trial comes up. Okay, so our bail system, the emphasis is on the least restrictive conditions. The criminal code emphasizes that bail conditions should be the least onerous necessary to ensure the accused attends court and public is protected, which is the most important, that the public is protected. Okay, if the judge or justice of the peace feels the public is not protected, they will not release you. Bail hearings. Accused individuals have the right to a bail hearing where the judge or justice of the peace will decide whether to release them and under what conditions. So in conclusion, Canada's bail system strives for a balance between individuals' rights and public safety. While the goal is to release individuals at the earliest opportunity with the least restrictive conditions, the system also acknowledges the need to protect the public and ensure the integrity of the justice system. The specific circumstances of each case are very carefully considered to determine the appropriate course of action. So, having said all of this, lately there has been obviously hue and cry because a lot of violent crimes have been committed by people who are already out on bail. So, Ontario Premier Doug Ford was the one who has been in the news lately to say, that this is what's happening. This is an article from the CBC by Lucas powers, and it's from October 28 in 2024. Ontario is calling on the federal government to make several bail-related changes to the criminal code, including eliminating bail for certain offenses and implementing a three-strike rule for repeat offenders. So, they sent a letter to the Federal Minister for Justice and Public Safety to get rid of the options for bail for those charged with murder, terrorism, human trafficking, intimate partner violence, that means domestic violence, okay, drug trafficking, or criminal possession or use of restricted or prohibited firearms and robbery. If, that's what they want. And I can see their point of view. These are very serious offenses. So anybody who commits these offenses should not get bail. I am in agreement with that. Absolutely, you should not be released the next morning. Because if you can commit these serious offenses, there's a chance that you may commit them again. I think they should be kept locked in custody until their trial. There should be a three-strike. The federal government should bring in a three-strike rule mandating pre-trial detention for repeat offenders. So if you breach your bail conditions, for example, in the past 3 times, then you don't get bail, period. I think if you breach, in my view, once, then you shouldn't get bail. You should stay locked up. The province would like to restore mandatory minimum sentencing for serious crimes. Now that's something that has to go through the Supreme Court of Canada, because they have to make sure that it's not unreasonable sentences that are being given. It has to be reasonable. Our Canadian Charter of Rights and Freedoms governs that as well. Okay. And they would like to remove credits for time served awaiting trial for repeat and violent offenders. And that's a really good idea, because if you don't get bail and you're locked up until your trial, that could be 6 months, it could be a year, then basically when trial happens, you get found guilty, and then the sentence, the defense says, well, he's already been in jail for 6 months to a year. That should count towards their sentence. I don't think that should be allowed. No, I think that should be taken out as well, and they should serve their sentence. Let's say they get a sentence of 2 years less a day. And if they've been already in jail for 18 months, well, then they just go back for 6 months, and they'll get out in 2 months for good behavior, and they're out in no time. No, whatever their sentence is, in my opinion, is that's the sentence they should serve. They should start serving their sentence from the day they're found guilty for that under the Criminal Code of Canada. It says this is what it is: 2 years less a day, 5 years. They should be serving that full thing, not get credit for time already served. So that's that. I think these things have been changed, and I think the new federal government with Prime Minister Carney will be bringing in much tougher bail reform when they present the budget this September. They already said that in the throne speech, that they will be tightening bringing in new bail reform. So, but the other thing that has to be addressed also, a very important thing, is that the province of Ontario is responsible for courts, okay, for the courts themselves. So, for example, as Minister Varani saying that I have previously raised about the adequacy of court resources, ensuring justices of the peace have appropriate legal training to make bail decisions, ensuring enough prosecutors are hired to contest bail hearings, and ensuring bail reviews are brought and when they feel error has been made, as well as the need to ensure there are sufficient jail spaces and resources for people on remand. So Premier Ford can bring forth the arguments, yes, that people are being released quickly, but he himself has to take the steps as well to say, make sure there's enough, jail spaces and resources for people that are locked up. If our jails are already severely overcrowded, then what? Really, where are you going to put these people, right? If we don't have enough justice of the peace, these people are not going to get listened to within 24 hours of their being arrested. There's already not enough jail capacity to house all these people. So basically, Premier Ford also has to step up and do his part by making sure there's lots of justice of the peace, there's lots of prosecutors, to address the matters that come up. Okay, the federal government has to step up and toughen the bail. So there will be a toughened bails. New reforms coming up for bails. I understand everybody gets upset. The police chiefs. If somebody out on bail commits a serious crime again, then there's a press conference with the police chiefs. There's a press conference with the, Premier Ford, and they all stand there and say, well, our bail system doesn't work. Well, this bail system is set up on the Canadian Charter of Rights and Freedoms. Okay, so at this time, that's how it's working. So everybody has to step up and make the changes that need to be made. And I think changes will be coming, 100%. Prime Minister Carney has promised it, so I think changes will be coming. So I definitely think, again, before I close off, that there is a need for bail reform, as I had pointed out those things just in the CBC article. There's definitely a need for bail reform, so the violent offenders do not get out. Okay? All right. I hope you liked today's analysis of the bail system in Canada, and it was informative. If you liked it, can you please subscribe, subscribe, and turn on your notifications. It doesn't cost you anything. It helps me out. Thank you very much for watching, and we'll meet again next week. Thank you.